there and taps his hands and you're just sitting there and he, sits there and rocks back and forth in the chair like a big old murderer or whatever he is, convicted. Up to this point of a case, not in handcuffs, not in shackles, one or the other, or both, and in orange.
Everybody, Excited Utterance here. My name's Hella, and that's one of my favorite intros that I've done on this channel. Even though I didn't make the song, can't take credit for that song. Nope, that was Wagner, Flight of the Valkyries, indeed. But yeah, I do enjoy playing that one, and I have to give credit. The map footage, the Google map footage graphics, that is from Architect. So Architect does some awesome work. So hi out there to Architect if you're watching later. Hello everybody. Yes, RIP Zana, Ethan and Maddie. Yeah, and Kaylee as well. Yeah. Yeah. Hey Diane, how are you? Hi all. I'm in bed already, but just popped in to say hi. Have a good live, everyone. Thank you, Diane. It's really nice to see you. Really nice to see you. AG is here. You touch this channel with Transfer DNA, lol. Please touch the like button with the Transfer DNA. That would be lovely. Very nice of you. Be careful though, don't touch anything else with that Transfer DNA. You could end up in prison. Maybe even on death row. We don't want that. Hey Brad, how are you? Now Sarah the Irish, you are a bit of a legend. Thank you for all the updates on X. You just posted something recently. Let me have a look. Yep, you just posted something with a case summary. I need to find out where you're getting these case summaries. I am geo-blocked from a lot of stuff on the Ada County Court website. So these case summaries that you're getting, Sarah the Irish, I need to work out how I can get to those. So there is some stuff that was dropped on the 13th, and one of them is interesting. It's a motion to unseal the IGG suppression briefing and hearing. I assume that's from the defense. So I don't have the actual document. I've just got the list that you've posted on X. Thank you, Sarah. And that's interesting to have something unsealed, because both the defense and the state have been very compliant, very much happy to keep everything under seal, which has been interesting all along. So yes, thank you for that. Hi Melissa, how are you? And KLF's there. Hello Dali, are you upset, are you, that I haven't said hello to you yet, Ilya T-Bone Satchel? I've already been talking to you today, but hi. Hi. Are you getting sick? Was that a cough that you're getting sick? Or are you just looking for me to say hi? Scott, Gross. Yeah. Scott, I need to say thank you for the work that you've done, having a look through the documents and updating me on your insights whilst I've been asleep. I wake up and there's all this stuff in the Discord for me. So thank you. I appreciate that. And I've gone and put some of that together in a little document that I can refer to today. So I appreciate that very, very much. And JC is here. Hello, JC Music Man. Flight of the Nancy Graces. Dear. Now, Mavka. You're my favorite troll, Mavka. And I've got a few. Yeah, tomorrow, guys, hey, bye, friends. How are you? Tomorrow, we have Sean on the channel. We haven't had Sean on for maybe a month or so. It's been a while. Sean's going to be on here talking Delphi tomorrow. So that will be fun. So it'll be good. Yeah, not that guy. Sean will be here tomorrow. So that will be fun. Okay, so let's get into it. Yeah, motion to unseal one is really interesting. It was only the case summary that was updated, so there's no docs. Yeah, I didn't think the docs were there yet, but the case summaries, I can't get to them. Would you mind, Sarah, sending me just a straight link to where you're getting those case summaries from, and I'll see if I can get through to them. I'll try a VPN. Yeah, potentially, Sean. Sean won't answer questions unless you yell. No, or unless you're an Aussie. Okay, cool. Let's get into it. So, guys, the big hearing is what? Today, for me, it's the 15th today. For you guys, it's the 14th because you're in the past. So it's less than 10 days away. Do you like the thumbnail? Do you like my thumbnail? It said counting down to 1, 2, 3. And I had to check with Ilya, because I was like, does that make sense? Because for me, in Australia, the 23rd of January is actually 2, 3, 1. So I had to check that actually made sense. Right. But it's 1, 2, 3. Maybe that's lucky. Maybe it's lucky. Who knows? Or maybe not. Yeah. So on 1, 2, 3, there is without doubt, most crucial hearing of this entire case coming up for the defense. This could end it. Kind of unlikely, but it could. It definitely could change the entire landscape of the case. Here's why. Because, and I'll just bring in because what we have is all of these being argued. Motion to suppress, motion to suppress, motion to suppress. All of these being argued right here. I'll just make it a little bit bigger. So on the 14th of October, oh no, is that right? 14th of the 11th? Yeah. See, I'm an Aussie. It's really hard for me to work out these dates. On the 14th of October, the defense dropped all of these documents, all these motions to suppress. Amazon, apartment, Apple, arrest warrant, ATT first warrant, cell phone data, Google, pen track trace device, person in ID, person in Pennsylvania, white Hyundai, 119 Lambsden statements redacted, and genetic info, and this biggie, the motion for a Franks hearing. That's all really quiet. We don't know what's in that because we can't see the attached memorandum. Oh, how I would love to see the Franks memo, but it is under seal, as a lot of things are. Motion for Franks hearing. We're still waiting, guys. We don't know. We don't know what the judge is going to say about this Franks hearing, whether there's going to be one or not. But his silence, I don't know. like people are speculating over his silence. He could have denied it already, and he hasn't. So I think personally that there's been so much said already about the wrongdoings in relation to the search warrants that it's going to be pretty hard for him to not allow this Franks hearing. But then again, we don't know what's in the memo. So, yeah, we'll see. Guys, there's also this other thing. Where is it? What we went through last time. Last time we were here, we went through the motion for I'll just get to it. I'll just go to it. We went through the motion for the sanctions in regard to the expert witnesses. So I'm just trying to find the actual. God, they're so hard to find. Might be underneath these. Motion for sanctions. Doesn't matter. I have it anyway. Motion to compel ICT material and for sanctions. Is that it there? That looks like it's that. That's it there. Yeah, that's the one. Cool. Yes. So we went through this one last time. And this is the one where he's wading through a sea of discovery. Okay, so this is a capital murder case, and nothing about it is clear-cut. The expert issues are complex, involving many different facets of DNA, cellular data, cell tower data, and drive testing, car identification, crime scene and blood spatter analysis, fingerprint analysis, forensic pathology, and electronic device analysis of the suspect, victims, and alternative suspects and social media accounts. At issue is the state's supplemental response to request for discovery regarding expert testimony and its exhibits filed December 18, 2024. Remember, last time, guys, we had a stream about what's the deal with the DNA, right? Because they didn't even have a DNA expert, right? So they came along and filed on December 18, 2024, and they were like, we have the disclosure lists 25 experts and provides curriculum vitae, 5 expert with expert opinion reports, and the others with reference to base number pages or items, but no opinion, data, or methodology. What the state's disclosure does not do is follow the rule which states that on written request of the defendant, the prosecutor must provide a written summary or report of any testimony that the state intends to introduce at trial or at a hearing pursuant to Rules 702, 703, or 705 of the Idaho Rules of Evidence. Okay, so we'll go into a little bit more of that in a minute, but the problem here is that they have only provided 5 of those, and 20 of them are missing. 20. State, do your job. Do your job is what the defense was saying back then. Now, yes, Mr. Kohberger must be able to confront the evidence against him, and to do that, it must be disclosed in accordance with Idaho Rule 16 and this court's trial setting order. The expert evidence disclosed by the state is woefully inadequate. This is a capital murder case, and compliance with the rules of discovery are not optional. Mr. Kohberger is prejudiced by the state's failure, and it is impossible for him to confront unknown expert opinions with his own expert disclosures by January 23, 2025, which happens to be the date of the hearing. Go away, AI assistant. I don't care about you. I don't need any AI assistant. hate it when all these programs start to come up with like, do you need assistance from AI? No, I don't. Okay. Right. So that was the one that we covered last time, right? And you're here kicking and punching things. Hey, DB. Something stinky with these Idaho goons. Oh, yeah. Yeah. How does one black out Adobe? Do I have that option? I don't know. Well, I love Adobe, except Acrobat. Acrobat is the most painful application. I can't stand the actual Acrobat software. I've got full Acrobat because I have the whole Adobe suite, and I can't stand Acrobat. It's just really difficult to use. Okay, so let's get into what the AI is Clippy 2.0. Damn, Clippy. Okay, so let's get into what the response to that was. So, of course, the state objected to this. They don't want to be sanctioned, and of course, they're gonna come along and go, no, we did everything right. We did everything right. We disclosed everything that we need to. Everything's fine over here. Nothing to see here. So let's have a look at that. Let's have a look at that. State objection. I accidentally left the wrong browser window. That is a boomer moment. Hey woman, how's it going? I went to open the next document and I opened it in the same browser window where StreamYard was. It's like, are you serious? What? What? Oh my god. Oh dear. Oh dear, oh dear, oh dearie me. It's not that early. Guys, if you want to buy me a coffee and wake me up, there is a link pinned to the top of chat. Yeah. Oh dear. Okay. I have never done that. Go away, AI assistant. It is, AI is Clippy. It is. It's like, did you mean to do that? Okay, comes now, State of Idaho, by and through the later county prosecuting attorney and respectfully objects and moves the court to deny the defense motion to compel ICR 16B7 material and for sanctions filed on December 27, 2024. Shut up, Ilya. Okay, you have boomered so many times, right? How many streams have you ended prematurely or not ended at all? You actually, yesterday you didn't end your stream. Okay? Don't do Clippy slander. Clippy's a perv. Okay. Relevant facts. The state has been actively engaged in replying to the defendant's request for discovery. Oh, gee, thanks. Thanks for that. There's only been 21 supplemental requests for discovery and 6 motions to compel. So, gee, thanks for continuing to comply, state. including materials related to potential expert witnesses, since the original discovery request was filed on January 10, 2023. Yes, as ICR 16J contemplates, discovery involves a continuous duty to disclose, which the state has and will continue to comply with. This specific continuing duty to disclose evidences that ICR 16 compliance is not a one-time event. Well, not for you. Defendant currently notes that this case involves a substantial amount of discovery. Defendant cites over 68 terabytes, and the state does not dispute this. The discovery received by the state from multiple agencies have been provided to defense in the same manner it was provided to the state. Okay, so basically what's happening is they're getting a Dropbox link from the feds and other people. It's a Dropbox link, right? And it's full of stuff. And they just keep forwarding it on, right? And then the state asks for it again, and then they forward it on again. And then they forward it on again, and then they forward it on again. And I don't know whether they're really checking whether there's anything new in there or not, right? Hey, Mrs. Potage, the state replies, it doesn't comply. Yeah, right? Last time that Ashley Jennings was asked whether or not there were the items that were asked for by the defense were actually in that Dropbox link, she looked with the blankest stare you've ever seen in your life. Like, she looked like a ghost. She was like, it's the Dropbox link we supplied. She had no clue. Like, zero clue. It's just, it continues on and on and on. Okay, so the state is in the same position as the defendant in this regard. Not really, because the defendant is likely to be put to death. The court record will reflect that the state has provided extremely detailed responses to the defendant's request for discovery and motions to compel above and beyond what is required by Rule 16. Okay, we're going to have a look at Rule 16 in a minute. On December 18, 2024, the state, in compliance with the court's order, filed its guilt phase experts consistent with ICR 16B7. These disclosures were filed 7 months and 24 days before the commencement of trial. Oh, isn't that nice? Right? So 7 months and 24 days before the commencement of trial. That was their deadline. So they're making out like that's like some big amount of time. So 7 months and 24 days before the commencement of trial. Oh, goody for you. That was your deadline, dudes. That's your deadline, right? So you got no choice. You've got to put your experts in by December 18. Yes? You don't have any choice. 7 months and 24 days. Whoa. Isn't that nice of you? As of the date of the filing, we are 7 months and 12 days before the commencement of trial. Oh, wow, look. You can do some maths. Nevertheless, defendant argues that he was prejudiced and requests sanctions. Defendant's arguments are without merit. Okay, so, let's see. 16. So 16J, the state will continue to supplement the response if the state later discovers or decides to use additional evidence. So that's the ongoing duty to disclose. So if after compliance with a request issued pursuant to the rule and prior to or during the trial, a party discovers additional evidence or the evidence of an additional witness or witnesses, or decides to use additional evidence, witness or witnesses, the evidence is automatically subject to discovery and inspection under the prior request. Well, yeah, okay, that's fair. The party must immediately notify the other party or that party's attorney and the court of the existence of the additional evidence or the names or the additional witness or witnesses in order to allow the other party to make an additional appropriate request for additional discovery or inspection. Okay, so that's just J. 16B. So 16B, let's just go back and have a look at what they're referring to with 16B. So filed its guilt phase expert consistent with ICR 16B. 16B, and these are Idaho criminal rules. Let's just keep that in mind. These are Idaho criminal rules. So expert witnesses. On a written request of the defendant, the prosecutor must provide a written summary report of any testimony that the state intends to introduce at trial or at a hearing pursuant to Rules 702, 703, and 705 of the Idaho Rules of Evidence. The summary provided must describe the witness's opinions, the facts and data for those opinions, and the witness's qualifications. Right, so they got one bit. They got the witness's qualifications. Right, so the summary must describe the witness's opinions, the facts and data for those opinions. Okay, so this is the state's objection, and they're referring to Rule 16B. And Rule 16B, so they don't have the data for 20 of them though, Scott. So 5 of them, they have it, but for 20 of them, they don't. That's what the defense is saying, that they don't have it for 20. They've just got a CV. Hey, Moonvale. How are you? I mean, sure they do. We'll come back to the rest of the they have 68 terabytes of evidence. So, okay, so here's my problem with that. So, do the experts just get to put their CV in and go, oh, and 68 terabytes of evidence? That's it, right? So, let's say I am a blood spatter expert. I'm a blood spatter expert, and here is my CV, and here's the 68 terabytes of evidence. That's it. Do they not have to be really specific and go, here's my opinions and the data, and reference the data? Do they not have to do that? Surely. Rather than just go, oh, but here's the discovery. Because it sounds to me like that's what's happened. Like, surely they need to be specific. Like, go to a lot more work than just go, here's my CV and here's the discovery. Scott, and the state has to provide a summary of what the expert is going to testify to. Yes, and they haven't, is what the defense is saying. They haven't. Hey, American Princess. How are you? Yeah, see, it seems to me that they haven't, because that's what they're arguing. Nope, they don't have to be specific. And this is the argument, right? So this is the argument. So do they have to be specific, or is it enough for them to just go, well, everything's in that 68 terabytes. You go work it out for yourself. Disclosure of expert opinion regarding mental health must also comply with the requirements of Idaho Code 18207. The prosecution is not required to produce any materials not subject to disclosure under subsection G of this rule. This subsection does not require disclosure of expert witnesses, their opinions, the facts and data for those opinions, or witness qualifications intended only to rebut evidence or theories that have not been disclosed under this rule prior to trial. Okay, so that's just regarding mental health. True? Am I misreading that? I think that's just... Okay, so that's Rule 16B. be, and then it referred to 702, 703, and 704. So a written summary or report of any testimony that the state intends to introduce at trial or at a hearing pursuant to rules 702, 703, 705. I don't have 705 here. I should get 705 up. Okay, so testimony of an expert witness, you're going to submit your CV to. A witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. Basis of expert opinion testimony. An expert may base an opinion on facts or data in the case that the expert has been made aware of or personally observed. If experts in a particular field would reasonably rely on those kinds of facts or data in forming an opinion or inference on the subject, they need not be admissible for the opinion to be admitted. But if the facts or data would otherwise be inadmissible, the proponent of the opinion may disclose them to the jury only if their probative value is helping the jury evaluate the opinion. Okay, well, that's fine. An opinion or inference is not objectionable. Okay, I'm missing 705. I need to go to the link. Okay. Oh, you posted 705. Thank you. Disclosing the facts or data underlying the expert's opinion. So unless the court's orders otherwise, an expert may state an opinion and give the reasons for it without prior disclosure of the underlying facts or data, provided that if requested, pursuant to the rules of discovery, the underlying facts or data were disclosed. But the expert may be required to disclose those facts or data on cross-examination. Okay, so basically where we're going with this is that the Idaho rules are less, the state's required to do less with the Idaho rules than based on the federal rules. However, it's kind of a little bit picking teeth, yeah? So it's a death penalty case, right? So he is afforded maximum due process. This guy they're trying to kill him, okay? And it's exactly the argument that Ann Taylor was making from the beginning and that Jay Loxton was making as well, and that is that why cut corners? Tell us what you got. It's not fair for you guys to be holding back and making us guess what you're going to be putting forward at trial. But then again, I feel like the state doesn't know what they're going to be putting forward at trial. Because, for a few reasons. Partly because there is this mountain of evidence. And when I say mountain of evidence, it's not necessarily inculpatory evidence. It's just a mountain of data. And both sides are struggling with this mountain of data. Yeah, exactly. It is a death penalty case, and everything changes once death penalty is on the table. It becomes a far more serious situation in terms of his right to due process, and we covered that when we had Steve Gosney on the panel for the discussion around the death penalty motions. It's why he's allowed so many expert witnesses. It's why he's allowed like these top quality lawyers. It's why it takes longer for it to get to trial. It's just once the death penalty's there, he is entitled to more discretion, more the court needs to pay greater attention to the fact that his rights, if they're violated, could end up in him being killed. It's so much data, it's insane. Hi, hey, Cole Harton, thank you so much. Hey, Factual Lie, good to see you. All right, let's keep going. All right, so defendant argues that he's been prejudiced and requests sanctions. Defendant's argument is without merit. Yes, okay, so you say. Argument. The state has complied with the court's order and Idaho Criminal Rule 16b-7 regarding disclosure of expert witnesses. On December 18, 2024, the state filed state's supplemental response to request for discovery regarding expert testimony in compliance with the court's unredacted sealed order governing further criminal proceedings and notice of trial setting order on October 9, 2024. That order stated as followed under Section C, discovery and expert disclosures. Also, let's just have a look at where is number one here. Let's go back. Where's number one? The state is in the same position as the defendant in this regard. Footnote 1. Defendant complains and... You keep complaining, Bryan. Defendant complains and appears to represent that he has not been provided with adequate information from the state. This is patently untrue. It's not true. It's not true. By way of example, to appreciate the true degree of analysis and use by the defendant of discovery that has been provided, the court need look no further than the extensive detail in the defendant's motion for Frank's hearing. Oh God, how I would love to see that. Someone leak it. Someone do something. I want to see it. The 20 plus supplemental discovery requests, yeah, there's been 21. And related materials. And the many other detailed substantive motions he has filed. By the way, hey DB, did you see that Jennifer Coffin-Licker thinks that Bryan Kohberger is the one filing all these motions because of this language, because they say, oh, because he has filed and Bryan Kohberger comes now and all that kind of stuff. And because it said that Bryan Kohberger continues to wade through a sea of discovery. You'd think he'd have some attorneys to help, right? Yeah, I always heard he was a bit of a whiner. Oh, look, I really have my doubts. I think she's just a desk girl. Has anyone actually met Frank? I hear he's pretty argumentative, right? He's always writing memos. Dear. Experts. A list of experts the parties intend to call at trial, including a copy of the expert's report consistent with ICR 16b-7 and a copy of the expert's curriculum vitae, shall be disclosed to the opposing party as follows. States guilt phase experts December 18, 2024, and the order refers to ICR 16 7, which states in relevant part, expert witnesses on written summary request of the defendant, the prosecutor must provide a written summary or report of any testimony that the state intends to introduce at trial or at a hearing pursuant to Rule 702, 703, or 705 are the Idaho Rules of Evidence. The summary provided must describe the witness's opinions, the facts and data for those opinions, and the witness's qualifications. Hang on. But Ann Taylor said that you didn't do that for 20 of them. Summary. Opinions, facts, data for those opinions, and the witness. She said that for 5 of them, all you did was the witness's qualifications, not the facts and data for the opinions. Opinions, facts, and data. She said that for 20 of them, you didn't do that. So I don't get it. Why are you referring to that? The defendant cites State versus Marin in support of his motion. Yes, he did. Defendant's motion to compel ICR 16.7, page 3. Marin was charged with driving under the influence of drugs, marijuana. The state filed the following expert disclosure for the forensic toxicologist. So Dr. Dawson is an expert in toxicology and pharmacology and will assist the trier of fact in understanding the evidence regarding the effects of drugs on the behavior and performance of the defendant as reported in this case. Dr. Dawson will utilize known and general accepted scientific principles of absorption, distribution, and metabolism and excretion of drugs. Testimony may include information on the effects of the drugs consumed by the defendant in this case and possible effects of said drugs. Okay, so that was what the state gave on that particular expert prior to trial. At trial, Dr. Dawson testified that dilated pupils, confusing speech patterns, impairment to balance and other psychomotor function, lack of convergence, and green coating of the tongue were all diagnosis indications of marijuana intoxication. Dr. Dawson also testified to the physiological effects of other drugs found in Marin's system. Ultimately, Dr. Dawson testified that it was his opinion that Marin was impaired and unsafe to operate a motor vehicle. The court held that the state's response disclosed nothing more than Dr. Dawson's qualifications. The generic response vaguely described the subject matter, not the content, of Dr. Dawson's anticipated testimony. The court held a mere list of topics or general subject matter which an expert witness may testify is not a discovery response that complies within the rule. Fair? The court also stated even if the state did not know all the details of Dr. Dawson's testimony at the time of the initial discovery response, okay, they're going to lean on this. ICR 16J imposes a continuing duty to supplement the response if a party later discovers or decides to use additional evidence. Discovery rules are drafted to safeguard the truth-seeking function of trials. The rules are designed to promote fairness and candor, facilitate fair and expedient pre-trial fact-gathering, and prevent surprise at trial. Yes, prevent surprise at trial. Yes, exactly, right. So, okay, so they're trying to say that this Marin that they're leaning on won't happen. So the case of Marin that they're trying to use as case law, that's not going to happen because we are going to keep disclosing anything that comes up in regard to our experts as we go along. As they learn new things, we're going to keep disclosing it. There's not going to be any surprises at trial, guys. Don't worry. Okay. By way of contrast, in State versus Coach, the defendant was charged with lewd conduct with a minor. The state filed the following expert disclosure for an expert. Ms. Yeager's curriculum vitae is attached. She'll testify to the dynamics of delayed disclosure as it relates to child SA. The state intends to elicit expert testimony from Midel Yeager regarding behavior of children who have been SA'd, and Ms. Yeager will testify that it's rare that a child immediately discloses their SA, especially when they know the perpetrator. Ms. Yeager will testify about the dynamics of child SA as it relates to grooming a victim, keeping the abuse secret, the effects and threats on whether a child chooses to disclose. 157 Idaho 89, 93 to 94, etc., etc. Coach argued that the above disclosure was insufficient because it failed to disclose Yeager's opinions and facts and data behind those opinions, as required by ICR 16b. Coach also claims the disclosure was insufficient because it did not include a summary or report by Yeager. The Idaho Supreme Court disagreed. The Supreme Court held that the disclosure informed Coach of the main opinion to which Ms. Yeager was going to testify, and while it did not specifically disclose that, Yeager's opinions were based on her training and experience, which would be better practice. It did provide her curriculum vitae that presumably disclosed her education and experience. This is so grey. State, do your job. Do your damn job. For goodness sake. Just. Yeah, this is. Yes, Arnie Bird's fate accomplice. Accompli. How are you? It is oi, trust me, bro. You're so right. I can understand that the state doesn't want to be sanctioned. This could be death penalty off the table, right? A sanction could mean death penalty off the table. In the previous document, the motion for sanctions, there was a footnote about the Vallow case and how a discovery violation led to Vallow's death penalty being struck. So it's a little nudge there. So I can see why the state is objecting, of course. But for God's sake, just do your job. Like, really. You've got 25 experts. You know the defense has 35 experts. So you've got 25 experts. And the deadline for the defense to come back with their expert disclosures is the 23rd of January. So 9 days away. And this is what they have to deal with. They've got a bunch of CVs, and it sounds like they have some very generic little summaries like this, right? So it's a death penalty case. Take it seriously. Bill Thompson, Santa is January. Chop, chop. Chop, chop. All the presents have been delivered now. Get back to work. Idaho Supreme Court in Coach discussed the scope of ICR disclosure requirements and looked to the federal rule of criminal procedure. Oh, and by the way, sorry, on that, the court approved his request for assistant attorneys, state attorneys, to help him without even a hearing. So he has help now too. He's got more elves. Okay. All right. We've probably exhausted this one for now. So yeah, he's. Oh, hang on. This one's interesting. Generic discovery response. Turning to the case at hand, on December 18, 2024, the state disclosed 25 potential experts the state intends to call at trial. The defendant takes issue with 22 of the disclosures, claiming they are insufficient. Now there's 22. All 25 of the state's disclosures comply with the court's order and ICR 16b7 and are not the generic discovery response as presented in Marim. All 25 disclosures encompass more than a mere list of topics or general subject matter which an expert witness may testify. Each disclosure informs defendant of the main opinion to which each expert will testify and the CV which that opinion is based upon as required by Coach. For experts, where the state does not have a report, as further held by Coach. If there's no data, the state doesn't have to produce data. Okay. The state addresses each objection to the proposed disclosures as follows. The state disclosed expert opinions regarding the toxicology for all decedents as detailed in the provided toxicology reports. Okay, sure, all right. So there's toxicology reports. Good, all right. Well, there's one. There's something specific you can point to. Done. In addition, the state included the toxicologist's curriculum vitae, which supported her opinions. Okay. This disclosure was not merely a topic list of general subject matter, which the expert may testify as precluded by Marin. Instead, it's the main opinion and the CV, which supported the opinion as required by Coach. Okay, who else have you got? The state disclosed special agent balance. The state's disclosure was adequately specific. The example S2 states SA balance will provide his opinion as the general locations in which the targeted cellular telephones were located at various times before and after the homicides at 112 King Road and the cellular phone's direction of travel. The attached report detailed the target cellular phones analysed and the dates analysed and the direction of travel. In addition, defence was directed to the cell phone records provided by AT&T and the drive testing files which support the report. By the way, we still don't have the cast report. I believe that the cast report is lacking in its entirety. So that, I believe, will be argued at the hearing on the 23rd. The defendant appears to be requiring compliance with the federal standard. This is what Scott was talking to me in the Discord about. Thank you, Scott. The defendant appears to be requiring compliance with the federal standard, which is much broader than ICR 16b7. The state's disclosure provides defendant with adequate notice of balance's anticipated testimony to satisfy the requirements of ICR 16b7. For exhibits S3 and S4, defendant correctly agrees these disclosures meet ICR. Oh, well, we agree on something. And I mean, it sucks because we can't see these exhibits. So, like, we don't know. Hey, Sleuthy, how's it going? For exhibits S5 and S7, the state disclosed 2 likely fact witnesses as experts out of abundance of caution and was clear about this intent. The defendant's argument that the state erred in this good faith disclosure is without merit. He loves that word, but merit. Without merit. In the event either of these witnesses are in fact experts within the meaning of ICR 16b7, it is clear from each disclosure exactly what these witnesses will testify to based on the provided disclosures. And again, we can't see the disclosures, so we don't know. For exhibit S8, the state disclosed the vehicle identification expert, SAIMEL. The disclosure, can't wait to see this vehicle identification expert. How do you identify this vehicle when you've got like blurry pictures of some just white car? The disclosure specifies he will testify to his use of forensic audio, video, and image analysis program. The forensic audio, video, and image analysis program, in italics, was used to determine the make, model, and year of a suspected vehicle involved in the 1122 King Road burglary and homicides in Moscow, Idaho, on or about November 13, 2022. On or about. Okay. Are you not sure? It is clear from the disclosure that this witness is an expert in vehicle identification. Is it? Okay. Well, court will decide that. Defendant has repeatedly been provided the images relied upon which are detailed in his report of examination, which was attached to the state's disclosure. The state's disclosure provides defendant with adequate notice of IMEL's anticipated testimony to satisfy the requirements of ICR 16b7. Exhibit S9, the state disclosed Kathy Mabbitt, the Latah County coroner. The state specially detailed each opinion to be proffered. Did they now? The opinions were supported by the attached death certificates authored by the coroner and the coroner's CV. The defendant fails to mention that in addition to being an attorney and an elected coroner, Ms. Mabbitt was a registered nurse for 44 years, which is detailed in her CV. The state's expert disclosure satisfied the requirements of ICR 16b7. For Exhibit S10, S13, and S14, the state disclosed forensic detectives. Okay, are they experts? These disclosures specifically listed each forensic item to which the witnesses would testify regarding. Matt, he identified as being white and possibly having 4 wheels. Yeah, I don't know how you go from just like a blurry image of a white supposed Elantra down to that particular vehicle when you've got no tags on the damn thing. Just, I am dying to hear this. I'm dying to hear this. It's just, this is going to be Bridge Guy all over again with a car. The witness's expertise is the process of extracting and identifying the data that is on each of the listed devices. Yeah. These sound like quasi-experts to me, but I'm sure they'll be allowed in. For Exhibit S11, defendant correctly agrees this disclosure meets the requirements. For Exhibit S12, the state disclosed an expert on crime scene reconstruction and bloodstain pattern analysis. The state specifically detailed each opinion to be proffered. The opinions were supported by attached reference report and CV. The state's disclosure provides defendant with adequate notice of this expert's anticipated testimony to satisfy the requirements of ICR 16b7. Okay, so I think where we're going with this is as the state has mentioned earlier, there is a difference of opinion as to the broadness of the disclosure that is required based on their understanding of the law. So the defense understands the law to be more broad, to require greater disclosure than the state understands it to be. And that's good for them because they have to do less work. But the state is like, well, we're both in the same boat. It's hard for both of us because we both got all this discovery and it's really difficult. Well, no, we're not both in the same boat because we've got a guy who you're trying to kill over here. So they keep going on about this whole thing about them meeting 16b7, ICR 16b7, which is an Idaho rule. And okay, if that's the law, this is all going to get dismissed, assuming that they have addressed everything here. Conclusion: the state respectfully requests that the court deny defendant's motion to compel ICR material and for sanction based upon the filings in this case, pursuant to 4th Judicial District Rule 5.3. The state is not requesting a hearing on this matter. I'm sure they're not. I'm sure they're not. I'm sure they don't want a hearing on this matter. Well, let's see, because the defense did they did respond. They responded. comes now, Bryan C. Kohberger, and through his attorneys of record, and hereby replies to the state's objection to defendant's motion to compel ICR 16b7 material and sanctions. Mr. Kohberger is protected under the constitutions of the United States and the state of Idaho to a right to a fair trial, to confront his accusers, the presumption of innocence, and effective assistance of counsel. In effort to protect his rights, the Idaho Supreme Court has pronounced rules governing criminal discovery through Idaho criminal rules. Mr. Kohberger asserts the state's failure to disclose expert opinions and supporting data violates his rights under both constitutions. Under both constitutions. Not just one, but both. Hey CH, how are you? How do LE manage to do an investigation without having some modicum of organization? Hang on, did we ever say that they managed to do an investigation? Like the federal issues don't matter, it's a DP case. Well, I mean, the state is the one killing him. Right? Where did I get to? Sorry. In an effort to protect his rights, the Idaho Supreme Court has pronounced rules governing criminal discovery through Idaho criminal rules. Mr. Kohberger asserts the state's failure to disclose expert opinions and supporting data violates his rights under both constitutions. Mr. Kohberger cannot fairly confront the evidence the state intends to bring against him when he does not know what it is. Well, that kind of makes sense, right? Like, I mean, like, smack me in the head, but that makes sense to me. His counsel cannot be adequately prepared to represent him at trial given the state's lack of adequate expert disclosures. Well, they just argued that, so let's see what they have to say. Failure to properly disclose expert opinions by merely disclosing a list or topics an expert may testify about, or leaving open-ended opinions, in essence shifts the burden to Mr. Kohberger. Well, you can't be doing that. Shifting burden, big no-no. Big no-no. He is forced to respond to unknown expert opinions with unspecified scientific, technical, or specialized knowledge while giving the state the ability to disclose its further or actual expert opinions in rebuttal filing on February 13, 2025. Okay, so we got a little bit of a cat and mouse game going on here, right? So state comes forth with really generic opinions, list of topics, and CVs, and go, that's cool, as per 16b Idaho rule. And wait until Mr. Kohberger comes along with his experts and actually complies with the rules as they see it, which are far more broad, right? And then they use that to come back with rebuttal, February 13, and then they disclose more, right? In answer to Mr. Kohberger's expert disclosures. So, yeah, that's shifting the burden. Isn't it? How is that not shifting the burden? Good point. But it won't fly. It won't fly. This failure to disclose expert opinions not only prevents Mr. Kohberger from confronting evidence against him, but also prevents him from assessing his need to file motions in limine. Where's my lemonade? And motions to exclude expert witness who do not meet Idaho's evidentiary standard. Idaho Rule of Evidence 702, 703, 704, and 705, otherwise known as Daubert-Frye hearing. Okay, so basically, if they do not meet the expert standard based on a Daubert hearing, yes, okay, deadlines are looming. Yes, they are looming. We're talking 9 days now for the defense. And there is a motion there to extend time. No response from the court yet. You'd want a response from the court pretty soon. Motions in Lemonade are due February 10, 2025. A motion to extend time to file some is filed simultaneously. Argument. The court has the state's sealed exhibits S1 to S25. The state's filing consists of over 400 pages. Oh, good. Okay. The state can burn through a lot of paper, as Jose Baez says. Mostly curriculum vitae of the named witnesses and a very, very few details of expert opinions, with a few exceptions. Well, that's kind of contrary to what Mr. Thompson was saying a moment ago, right? Approximately 2,000 pages of discovery are referenced in the DNA disclosures. Really? The court does not have the discovery pages in the expert disclosures, but for one example, attached to the state's objection as S1, most of the disclosures have catch-all phrases that the expert will rely on the work of unnamed others, that the disclosure is meant to be an aid, but does not encompass all finding, impression, conclusions, or material related to this expert's involvement in the case, or that the disclosure does not in any limit the scope of the expert's testimony. Okay, Scott, you had something to say about that, didn't you? Just a moment. Yeah, okay. So, in regard to the whole thing about the catch-all phrases, um, that would need to be dealt with under 16J, is what you said. So 16J being, go to 16J, the ongoing duty to disclose. So as required by 16J, the state will continue to supplement the response if the state later discovers or decides to use additional evidence. So continuing duty to disclose if, after compliance with the request issued pursuant to this rule and prior to or during the trial, party discovers additional evidence or the evidence or of an additional witness or witnesses, or decides to use additional evidence, the evidence is automatically subject to discovery and inspection under the prior request. The party must immediately notify the other party or that party's attorney and the court of the existence of the additional evidence or the names or the additional witness or witnesses in order to allow the other party to make an appropriate request for additional discovery or inspection. If they don't, that would be Giglio territory, wouldn't it? A testimony, or if it's an exhibit, then that is Brady territory. I'm only a fake lawyer, so correct me if I'm wrong. Yes. See? Thank you. Okay, let's keep going. Okay, places Mr. Kohberger at a disadvantage because he cannot prepare for the unknown opinion of an expert that would be proffered for the first time on the witness stand in front of a jury. The state discloses disclosures violate his constitutional rights under the 6th Amendment and 14th Amendments to confront and cross-examine the witnesses, confront the evidence that the state intends to present, and his counsel's ability to effectively prepare. Some of the expert disclosures are extremely broad and encompass topics that are not touched upon in any reports or discovery provided. Oh, that's a big deal. To say that it's not touched upon in any of the discovery provided, that says to me that they have been through all the discovery. How can they say that? Okay, that's kind of big, right? For them to say that it's not touched upon in any of the discovery tells me they've been through all the discovery. Because how can they say that? These disclosures do not allow Mr. Kohberger to evaluate the scope of the opinion, assess how his own expert witness will need to respond with countering opinions, prepare to confront the evidence the state intends to elicit, allow counsel to competently prepare for trial, and determine if a motion in a limousine or motion to exclude will be needed. Other disclosures contain lists of areas of testimony without more. Mr. Kohberger is provided no clues about the expert opinions on discovery disclosures that are vast, hundreds of thousands of pages. Attached as Exhibit B under seal is a more detailed argument relating to the lack of disclosure for specific experts. I was just about to say, you better be more specific than this, Anne. But she has. Because, yeah, up here she's just going on about really broad matters. But, yeah, then she's gone and attached Exhibit B. So, good. Which we can't see. The state's objection to defendant's motion to compel ICR acknowledged its duty under the rules, the quantity of 68 terabytes of discovery, which we keep hearing. It's funny that it never changes. It never, grows. It's always 68 terabytes, right? So it's like, there's been 21 motions to compel now. Sorry, not motions to compel. 21 supplemental requests for discovery. They keep handing over supposedly more stuff, like they add an extra thing onto the end, but it never grows. Yeah, that's what I was trying to work out earlier, if the defense had been through all discovery or not. Well, they just kind of said they did, Scott. That was a little bit of a giveaway, wasn't it? A terabyte's a lot. But, I mean, man, they've been working hard. And it's been 2 years. And look, here's just between us, here's my opinion. They've been handing over that same Google Drive link over and over and over again. I don't think anything new's been added to it. I think they just continue to add give the same thing over every single time. And I think they've probably got some software that can check whether there's any changes made to it every time. Maybe there's one file added or one file changed, not much. But I think they're able to tell, yeah, whether it's changed. But yeah, maybe they have. Maybe they have been through it. I'm sure it's the same link, but no, I mean actually the same set of folders with the same files in it. That's what I mean. Right? I think it's the same thing. I don't think they do anything to it. Because I think they don't know. And the state even said it in the other document. They're like, we provide the same discovery that we've been provided. Remember that? Remember they said that? We're in the same boat. We provide the same discovery provided to the state. So who's giving it to you, dudes? Yeah. The state interprets a motion to compel as one of complaint that adequate information has not been provided. See footnote 1, page 2. Yeah, they did say complain. Mr. Kohberger's argument is that given the overwhelming amount of discovery in this capital murder case, compliance with discovery rules related to expert opinions is vital to be informed of expert opinions being offered against him. Mr. Kohberger's experts need to know exactly what opinions and supporting materials each of them is confronting in this case, as well as allowing competent representation by counsel. He needs to know what specific technical or specialized knowledge the witness holds to qualify him or her as an expert. The discovery rules are designed to safeguard the truth-seeking function of trials, promote fairness, and/or to facilitate fair and expedited pre-trial fact-gathering, and to prevent surprise at trial. State versus Marin. Right. Hang on. What is this? As a point of reference, a single terabyte is the equivalent of 75 million pages of text. Yes, but it's not all text though, right? There'll be a lot of video in there. Yeah, okay. The expert witness the state discloses are relying on underlying data and technical or specialized knowledge, but what they intend to testify about using such knowledge is unknown. Footnote 2. We'll have a look at footnote 2 in a minute. Mr. Kohberger must be able to confront the evidence against him, and to do that, it must be disclosed in accordance with Idaho Rule 16 and the court's trial setting order. Yes, so the dates. The expert evidence disclosed by the state is inadequate. This is a capital murder case, and compliance with the rules of discovery are not optional. Mr. Kohberger is prejudiced by the state's failure. It is impossible for him to confront unknown expert opinions with his own expert disclosures by January 23, 2025. Okay, so this footnote number 2, the state submitted Exhibit S1 to its objection as an example of discovery that qualifies as an expert report. This exhibit is a list of items collected. If the witness associated with this list is simply a chain of custody witness, an opinion is not necessary. If the witness will testify that evidence was collected in accordance with her training, proper procedure, and lab protocols, that calls for and qualifies as her opinion. If this witness testifies that others gathered evidence in accordance with proper procedure and protocols, that also qualifies as an opinion. The lab protocols and evidence collection procedures have not been disclosed. If the state wishes to elicit her opinion regarding whether or not evidence was collected in accordance with her lab training and lab protocols, that is an opinion. If the state wishes to elicit any results of the tests and what they mean, that is an opinion. This is a good example of how the state's disclosures related to DNA are lacking in this case. I found that odd that the lab procedures haven't been disclosed. Yes. Make of it what you will. Make of it what you will. All right, let's see. I wanted to just note that this has happened. Go away, AI assistant. Go away. Stipulated motion to file defendants replies to state's objections to Franks and IgG under seal. So we don't know what's been happening with the Franks and the IgG, so the investigative genealogy. sorry, genetic, get this right, genetic genealogy. So there was a motion to suppress the IGG, so that's what that is, and there's a motion for a Franks hearing. And the responses, everything that's happened since, it's all been stipulated, like no objection on either side, for it all to be under seal. So we don't even get to see the arguments, the motion arguments, not just the exhibits, the arguments, right? So comes now Bryan C. Kohberger, by and through his attorneys of record, and with a no objection from the Latah County Prosecuting Attorney's Office, and hereby moves the court for an order to file their reply to the state's objection to defendant's amended Franks memorandum, and their reply to the state's objection to defendant's motion to suppress and memorandum in support, read genetic information under seal. So, yeah. Very secretive. Both sides are really happy to keep all this stuff secret. So make of that what you will. Also, can not like it, or you can look at it and go, well, maybe there's stuff in there that may be misinterpreted by the public. I know that does happen. That does happen. I stand by that the defense should not have put the word stargazing into the alibi, because unfortunately that got completely blown out of proportion. Everyone just looked at the word stargazing and went, that's ridiculous. What a stupid alibi. Who does that? Whereas it's irrelevant. He just was 40 miles to the west. Who cares what he was doing there? If the phone is tied to the car, as per the state's timeline, and his phone was 40 miles to the west, who the fuck cares what he was doing at Hawaii Park? Whether he was stargazing or doing push-ups or making out with a chick. Actually, that would make a difference because you have a witness. Who cares? Who cares? But the word stargazing just, it blew everything up and people went crazy over it. So, I mean, we're not at trial yet, so maybe it's just best that some things do stay out of the public eye. People do a Nancy Grace sometimes. Okay. Now, subpoena. We have a subpoena. You are hereby commanded that, laying aside all excuses, you appear in the District Court of 4th Judicial District of State of Idaho. This is by Trent Triple, the clerk of the District Court. Hey, so as opposed to Becky Hill, we have Trent Triple. He's the clerk of court. So, oh wow, I don't know if there's two witnesses coming in that have been subpoenaed, but it looks like is it by the defense? Yes, it's by the defense. So yeah, we have a defense witness coming in, being subpoenaed. And look at this, 2 days, guys. 2 days. So it's not just the 23rd, it's the 24th as well. We have a 2-day hearing. This is big. This is big. Okay. Now, scheduling order. Go away. In preparation for the hearings of ICR 12 motions scheduled to begin January 23, the court hereby orders the defendant shall disclose its witnesses, exhibits, and experts' opinions, if any. Okay, so these expert opinions are for this hearing. So January 9th, that's already passed. The state shall disclose its witnesses, exhibits, and expert opinions, if any, by January 16, and defendant shall disclose any rebuttal disclosures by January 21. It's all on, guys. It's happening. It's happening. And what else have we got? We have state's response to 20th. Hang on. Oh, yeah, this. Okay, so the 21st supplemental response to discovery. Guys, this is what we get every time there is a supplemental response to discovery. And yes, we're up to number 21 now. So the state comes along with one of these documents, and it is just a copy of the previous ones. Comes now the state of Idaho by and through Lader County prosecuting attorney, and the state incorporates the following responses as fully set forth at this point. So this was on 27th of December, and they go and they list out all of these. So it started on the 23rd of January 2023, incorporates the following responses as fully set forth, and we have state's response to request for discovery January 2023. Weren't they good days back then when we thought that, you know, they'd come forth and everything? It's kind of like when you save a file and you save it as like draft 1, and then the file names start to get more convoluted over time. State's response to defendant's first supplemental request for discovery, February 21, 2023. And then it goes on. State's response to defendant's second supplemental request for discovery. Check it all out. Look at this. May 12, 2023. May 12, 2023. So response to defendant's motion to compel. So that was the first motion to compel. Didn't even have the word first on it. We have defendant's first, second, and third supplemental request for discovery, June 8. Fourth supplemental request, 16th of June, 2023. And it goes on and it goes on and it goes on. So this document just keeps getting amended. And here we are, more. Look at it all. Just look at it all. State supplemental response to defendant's fourth and response to fifth motion to compel. And this is what I have to say to anybody who thinks that Bryan Kohberger is stalling and Taylor is stalling. What a load of crap. This is what has been holding things up, right? Apart from the fact that it's a death penalty case and he has, like, his attorneys have work to do. Like, death penalty cases don't just go to trial in 6 months. As argued very effectively in his motion to strike death penalty, where it was put forth by Jay Logston that there is a tension between two constitutional rights, where there's a right to speedy trial, and there's a right for his counsel to be fully prepared for trial, or for him to be fully prepared for trial. And how can that be when you have this mitigation phase to be prepared for? And the mitigation phase, assuming that he is found guilty, requires mitigation experts to be prepared for trial as well. That takes at least 10 months. And the Idaho rules of speedy trial rules are 5 or 6 months. I think it might be 5 months. So how do you have a speedy trial and then also be prepared for a death penalty case? So you need to choose between two of your rights. It's an excellent argument, but it was lost on Judge Hippler at trial court level. And Steve Gosney basically said that it's not an argument that was intended for him. It's an argument intended for the Supreme Court. But one day it will probably be successful, and it might not even be Bryan Kohberger who is the one who is first to benefit from it. But assuming he's found guilty and sentenced to death, and he makes it that far, somebody else wins an appeal based on that, then he would have that case law to fall back on. Yeah, don't think speedy trials are real right anymore anyway. Well, I mean, it is written to be. Hey Amanda, how are you over there on Twitch? Okay, state's response and supplemental response to defendant's request to discovery, filed September 4, 2024. State's response, blah, 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 blah. So the last one, state's response to defendant's 20th supplemental request filed. Oh, I haven't even brought up the latest one. So the latest one has is state's response to defendant's 21st one is written underneath there. You could actually just lay these on top of one another and they would line up perfectly except for the very last line. Unbelievable. There's just so many of them. Response to discovery. Oh, there it is. Yeah, there's the 21st response to discovery. So yeah, you can see it's actually exactly the same document. There you go. Oh no, I've named it the wrong thing. 21st, 20th. They're so similar. State's response to request for discovery regarding expert testimony. Oh, this is the one. Okay, and they've even put the last one there. They've even put state supplemental response to request for discovery regarding expert testimony is on there. Okay, so guys, in regard to what might happen over those 2 days, look, it's by far the biggest hearing there's been to date, and here's the reason. Let's go. Here's the reason. It's because of these, right? So these motions to suppress, they're the biggest deal, right? So if his browser has lost connection to your screen share audio, oh, that's okay. Yeah. If any of these motions to suppress are granted, then that changes the landscape of the whole trial. If the big one is granted, and that is the IGG, so the search that led to finding Mr. Kohberger in the first place, so the investigative genealogy, if that is found to be an illegal search, then that's called fruit of the poisonous tree, and that means that everything else is a domino effect. Chances of that are pretty slim, but I also have a feeling that if it can be proven that that is an illegal search, then we have a problem with Judge Hippler. His only thing that's ever been overturned in criminal court is a motion to suppress. No judge likes to be overturned, right? So it's gonna he's gonna be in a hard spot if there's a lot of evidence to prove that that was an illegal search, or any of these that there were illegal searches going on. Then I don't see how we can just ignore that. I know judges are asshole. Yeah, I will, Dolly. Yeah, so I know judges are asshole, but that's the thing. I don't see how he can just ignore that. And well, this is going to be his moment, right? This is going to be his moment to show whether or not he has any balls, right? Whether or not he has any integrity, And yeah, he could be overturned. And that would be this is a huge case. The whole world is watching. And if he just goes and gives everything to the prosecution straight off the bat, under all of this scrutiny, it's not going to be a good look. It's not going to be a good look. All right. I'm just going to just stick with me for a second, guys. I am going to redirect you all to Miss Ange. Miss Ange. Now, the reason she is live right now is because the lovely Mr. McClelland has spoken. Isn't that great? Don't we all just need to hear from him? Yep. Now, tomorrow, guys, we have Sean here, and he's going to be talking with us about the juror that spoke, and not just about the interview. There's a lot of talk online about the potential for juror misconduct, and there being a complaint about that. I'm not sure. I don't really think so, but we're going to bring up the jury instructions and the rules around that from Indiana, and we're going to go through that and look at it in relation to the words that she said, and just sort of iron that out, and also get a bit of his take on what's happened with Delphi. So he's covered it quite extensively before the trial happened, and he watched a fair bit of the coverage. So it's always good to get a different point of view, and Sean's amazing. So we'll be doing that tomorrow at 6 p.m. Eastern. I have not put the stream up yet, but guys, make sure that you're there for that. And there we go. I have updated, and we're going to be heading over to Ange R&M. Make sure you say hello, Rain, when you get there. So 23rd is this hearing. Obviously, I can't be streaming it live. I'll be up all night, but I will be doing reaction videos to it each night. So 23rd and the 24th, come here and come along, and we will we'll be doing the highlights for the day. Thank you guys for being here, and see you tomorrow, 6 p.m. Eastern. Me and Sean Delphi-ing, and it's time for the song. It is time for the song.
Her name was Ella. She was an Aussie. She was a fake lawyer from the future. She got on YouTube and made some live streams. Her co-host is Donnie, and she dances sometimes. The words are always so loud, and because she's an 803 to be said.